welcome back to the Business Immigration Benchmark. As you may have noticed, we have slipped into a summer schedule. And what that means is we'll be delivering episodes when I'm in the office and in the studio. I will be taking and have been taking some time off to vacation with my family and friends and refresh for the challenges and year ahead. I hope all my listeners are doing the same. With that, today's episode, we're diving into temporary protected status, or TPS. And I realize that this issue has been developing for many months now. The issue being the rescission of TPS status for Cubans, Haitians, Nicaraguans, and Venezuelans. And if you want the latest, tune in to Rapid Fire Wednesdays. My colleagues, Miki Matrician and Kimberley Robidoux, are doing weekly updates and have covered TPS and how to manage the I-9, how to think about the ongoing litigation on their weekly Wednesday broadcast. So tune in there for more specific information about the ongoing litigation. Today, my intention of covering this topic is to talk about what TPS is. It's not a typical classification that global mobility leaders are supporting, and I'll explain why. I'll also talk a little bit about how to think about managing TPS if you are a company that has individuals on TPS and are dealing with how to support the employees through the rescission, if there is any opportunities to support them. And then finally, what's to come on this issue and how to think about it if you have to report up to leadership within your company. So kind of a lot, but we're going to dive in and we're going to cover it from a broad topic. Again, I'm not going to cover the ongoing litigation. It's quite technical. And so tune in to Rapid Fire Wednesdays that my colleagues are diving into with more technical guidance. So with that, what is TPS? Well, TPS was created by Congress in 1990, and the intention here was for a humanitarian purpose. And the Secretary of Homeland Security is given the ability to designate a foreign country for TPS due to conditions in that country that temporarily prevent the country's nationals from returning back home to their home country safely. And some of these conditions might be an armed conflict, like a civil war, an extreme environmental disaster like an earthquake or hurricane, or other extraordinary circumstances. Now, generally, the way that the Secretary of Homeland Security issues this is that there's some extraordinary event, like a war going on in the country, and in an effort to give those foreign nationals who are present in the United States already some relief because going back home may not be possible or incredibly dangerous or difficult, the Secretary of Homeland Security says these foreign nationals that are already present in the US at the time of the national disaster have this temporary status to stay in the US and receive a work permit. They're protected from removal or deportation, and every around 18 months, but it's not always that specific. Every so often, the Secretary of Homeland Security reviews the state of the home country to re-up or redesignate extended temporary protected status. So again, this is meant to be sort of a temporary relief for individuals already present in the US to remain in the US because it is so dangerous or difficult for certain foreign nationals to return to home country because of what's going on in home country. Now, I see this from a pretty specific lens in that I support, again, employment-based immigration, so often professionals, high-skilled labor. So the folks that I often see that have temporary protected status are someone who entered the US as a student, and then their home country experiences these extraordinary events. So some cases that I can think of are I've supported F1 students who are from Ukraine. They've matriculated, graduated from their master's or bachelor's program, and then are hired by my clients who sponsor them for H-1B or whatever it might be. And so if they're not reseated in the H-1B lottery, some of these individuals did secure United for Ukraine temporary protected status. So I'm seeing it from, again, TPS through a very specific lens. There are, of course, other stories where foreign nationals are present in the US and are able to obtain the work permit and temporary protected status to remain in the US. Now, once granted the TPS, again, the foreign national individual is only eligible to remain in the US and remain work authorized so long as the Secretary of Homeland Security continues to redesignate or extend the temporary protected status. And what we saw at the beginning of this year was the Trump administration announce and ultimately Secretary Noem revoke temporary protected status for Cubans, Haitians, Nicaraguans, and Venezuelans. And once that decision was published and set to take effect, there was lawsuits. I'm not intending to get into all of the lawsuits because honestly, the litigation is quite technical and is still ongoing. But that's all to say that the revocation of the temporary protected status while still active has never been done by another administration. So it's leaving employers and foreign nationals super confused about who's affected and what it means for their status. We've brought up the delicate status of TPS when I was talking about the H-1B lottery and how a lot of my clients, with the knowledge that TPS may be going away, started sponsoring any eligible individuals for the H-1B lottery to try their hand at securing a more stable status for these valued employees. Wow, that's kind of a lot. But what I want to move into now is just like, what can you do as a global mobility leader, how to think about the issue if you haven't already? Well, you can think about it through the way you're being notified of whether you have employees on TPS. You might be notified directly by the employee. The Department of Homeland Security is notifying employees if their status, their TPS is revoked. So if you are notified by the employee that the employee's TPS has been revoked, they might self-depart or, resign from your company. That is some of the language that the Secretary of Homeland Security is giving these TPS beneficiaries who are having their status to revoke, because once the status is revoked, they may be subject to removal or deportation if there's no other status that these individuals can apply for or have already applied for. If you're an E-Verify employer, you will be notified, if you haven't already, of status revocation for these impacted TPS beneficiaries. So through your E-Verify program, you'll want to find out who's administering that, who's the contact person within your organization. The E-Verify program is sending out alerts if you have any impacted employees who have had their status revoked. If you're not an E-Verify employer, this is where it gets a little tricky, where if the employee hasn't notified you of their status revocation and you don't receive the notification through the E-Verify program, the only way that you would know or could discover whether you have individuals that may be subject to TPS rescission is to go through your I-9 or workforce program, if you have that available through a software, to review the employees you have on I-9 that are work authorized through the specific TPS employment authorization document codes. So that's all to say that there are ways through your HRIS or workforce systems to search for these employees. And then through a very technical review of who within the Cuban, Haitian, Nicaraguans, Venezuelans program with the correct EAD code may be subject to the rescission. That's a lot of work and, of course, is really technical. So if you've got questions, we recommend you work with counsel to navigate through this really tough issue. The second piece you want to be really aware of is no matter how you're being notified of the status rescission, is how you're navigating the conversation with the employee, because the employee may have another basis to remain in the US and another basis to be work authorized. Now, frankly, their ability to remain in the US is quite narrow. There aren't a lot of options for these folks, but they may have another basis to remain in the US and be work authorized. In fact, a case I've had recently this week for an employer who was notified through E-Verify of the TPS revocation of one of their employees. In those conversations, the employee was able to present another status receipt notice, which presented him as continuing to be lawfully present in the US as an asylum applicant, and that the asylum applicant also applied for an EAD pursuant to this asylum application. Now, they don't currently have the asylum EAD in hand, so we had to coach the employer through how to navigate that conversation with the employee and what was the employer's process for either maintaining employment with the employee on an inactive status, terminating the employee. These are all going to be some policy questions that you'll want to make sure you're closely collaborating with employment counsel to ensure you're following your state's laws regarding employment, and also immigration counsel to review any documentation that these employees may present that may indicate additional work authorization status for the purpose of re-verification. Phew, not easy stuff. That's all to say, TPS is something that, as an employment-based sponsorship program that you might be managing as a global mobility leader, this is all going to be very new to you. It's all very difficult and all subject to litigation. One thing that we can predict or project here is that this is going to continue. So while we have the Cubans, Haitians, Nicaraguans, Venezuelans currently subject to this rescission, it is predicted and very likely that the other countries I named will also have their programs rescinded or not extended. So these are things that if you don't know how to run these reports in your workforce management system, you're going to want to walk through that with counsel to understand just what your population of TPS employees are, so that you can notify managers, notify leadership of this potential gap in maintaining your employees and your talent in the critical roles that they serve in. So, another challenging issue from this administration, we're here to help. I hope this was helpful in the sense of identifying the issues, walking through what they look like and how to think about the issue as well as what's to come. For more technical guidance, reach out to your immigration counsel. This is going to be an issue for the year and years to come. Thanks for tuning in to the Business Immigration Benchmark. We'll catch you next time.